perhaps dubiously titled "Changing Expectations." We tried to pick out these titles for each session so they sounded like they meant something but really didn't, and I think we were pretty successful in that regard. That does not change the fact that I think the presentations have been very good. And for our main speaker in this last session, we have my old friend Bob Thompson, professor at Vanderbilt Law School and School of Management. And then as commentators, Professor William Birdthistle at Chicago-Kent College of Law, and our own David Porter, retired partner at Jones Day, graduate of this law school, and now adjunct professor teaching securities laws, the two securities law courses. So, okay, Bob.
Thanks, George. I'm delighted to be here, and thanks for staying around. My topic, as shown up on the screen, is what Ed Rock alluded to in his closing comments about, well, given what we thought about the corporate governance and given what we've talked about shareholders particularly, one way to test it is, would it have made a difference in the events of the last year? And that was the point of my thought process here, and I end up where both John and Ed end up, which is not very encouraging, frankly. But here's the spiel. Think about the last year, and it really is a litany of traumatic events. I mean, 2 of our 5 biggest investment banks folded, just gone. All the other big ones have converted to another form of business. It's not just investment banks. Our traditional banks, many of them, the biggest ones, have lost as much as 80% of their value, some 90%. Not just banks, insurance companies. AIG just is still sucking billions from our taxpayers. It's not just the financial industry. 2 of the big 3 are approaching bankruptcy, General Motors and Chrysler. GE has lost its AAA credit rating. General Growth, I got on the general part and I got carried away. General Growth Properties is gone bankrupt this week. You don't want to be a general in this economy. So it's not just financials. So surely, if we had shareholder power, they could have done better. Because who could have done worse? I mean, this is so that's the premise to examine for this period. If you think about the solutions that have been proposed for the financial crisis, there was just tons of focus on the G20 meeting and about the change in international regulation that was going to come from that, and then it kind of, I think, disappointed on that score. But the focus of that discussion was systemic risk and how we needed to regulate that. And it's led to an expectation, still anticipated from our national government, that we'll see a change in U.S. regulation in the financial industry. And I think what's interesting from the standpoint of today's discussion is what will be the relative role of the Fed and the relative role of the SEC and others in that point. It looked like for the first period of time, it looked like everything was going to be done by the Fed because they were going to be the savior of systemic risk, and the SEC was kind of slighted. I mean, there were, to me, there were all the pictures of last summer, last fall. You'd see pictures of the Treasury Secretary and the head of the Federal Reserve, and they'd be rushing into a meeting. And there'd always be a third person in that group who was the chair of the SEC, but no one ever paid attention to him. And it was 3 of them, but only 2 of them made a difference. So the question is, well, what's the SEC going to do? Well, and the SEC really had a bad fall in terms of the consolidated entity supervisory role that didn't go so well, the credit agencies regulation that turned out to be a real problem. And so what's happened recently is that they've settled on shareholder power as one of the current points of focus for the SEC, and so it kind of that fits into today's discussion. this is high up on their agenda again as a solution to what we've done for the last year. And then the last point of reference is there was a Carl Icahn op-ed piece in the New York Times a couple of weeks ago. And he said basically disenfranchised, again, apropos to today's topic, disenfranchised shareholders are at the root of the financial crisis. So he lays it directly to this governance point. And he says boldly that enhanced shareholder rights would help avoid the meltdown. So that's the premise for my discussion. I'm going to look at three things. First, talk about there has been a dramatic change that has strengthened the role of shareholders in recent years, and I'll talk about that. Secondly, I'll give examples, particularly coming from voting and litigation and also in the takeover area. And third, I'll then say, okay, what do we make of this? And I end up being skeptical of, is this going to make a difference or not, because of incentives and motivations that I'll talk about. So those are the three things I want to cover in my time. In terms of shareholders, circa 2009, this is the positive story as to why we might see a change. There has been a dramatic change in the census of shareholders compared to 2 decades ago, or pick your time. This is not, the census of shareholders is not the Burley and Means individual mom and pop shareholders dispersed across the country. As has been alluded to already today, we have institutions owning 80% of American public corporations. We have these intermediaries that are just have determined what we're about. Also, as the morning discussion showed, this spectrum of institutional investors is really fairly broad. They're not universe. You have traditional institutions that have been around forever, like banks and insurance companies, and then we have mutual funds that are a key owner. We have company pension funds, we have union pension funds, we have public pension funds, and we have hedge funds, and this doesn't exhaust it. The point that I think is worth taking from this morning is that they don't all act the same. So in acting, is there going to be a change? We have to look at the differences of those different groups. But this is a dramatic change. The other change is really, I think, technology driven, and it's important to focus on how it is driving down the cost of exercising shareholder power. And because of that, there is a real potential for something different. And it's actually pretty dramatic, I think. Computers, first off, make it possible to manage just incredible amounts of information, and that drives down the cost. The Internet has decreased the cost of communication, and that drives down the cost. We were talking at lunch about what it cost Catherine's budget in terms of just communicating, and it's less than it was just a few years ago. Globalization has introduced new economies of scale and new entrants because companies are now global. And then the fourth one, maybe perhaps not as obvious, is just affinity among institutions as lowering the cost of shareholder action. If you have, there was a reference to meeting with 50 shareholders or meeting with 30 shareholders. This is a whole different game in terms of your cost, if that's all you're talking about. So I think this is a really noticeable different state of play that ought to say something different about the role for shareholders. What I find interesting is that this is all market-driven. This is all technology-driven as opposed to being regulatory-driven. So if you compare it to Annik's presentation before lunch, focusing on the law hasn't changed that much. There is internet proxy. You can post your own. There is some regulatory change, but the much more dramatic change has been outside of the law. It's been in the regulatory. And the bottom line is, it is much cheaper to participate, to govern as a shareholder than it was even 2 decades ago. So do we see a change? The answer is yes. We see dramatic differences in shareholder power. I want to focus on voting and litigation. Voting, some you see in takeovers, although what I find interesting is this is not the dominant place you see it. Voting is not, takeovers is not the place that this has shown up the most. there has been a noticeable jump in voting to block takeovers on the bidder side. It is now much easier, and some hedge funds have gotten into this, to block takeovers because, as you know, almost all of the premium in takeover bids goes to the target. The acquirer ends up the same or slightly down. There's an incentive if you're a shareholder to oppose it, and we have seen examples because of the decrease in cost I just referred to of activist shareholders blocking takeovers. Third, we see an increase in partial slates for board input. That activist shareholders are using this new space to not push to control the board, but to have representation on the board. Now, but what I find interesting is, okay, what do they do once they get that? And what the data shows from the last 5 years is that they tend to use that power to push forth for selling assets, or for dividends, or for distributions. These are things that financial bidders tend to do. I mean, I teach mergers, and I try to get the students to distinguish financial bidders from strategic bidders, people in the industry from people outside the industry. What is interesting about activist shareholders in this regard is that they are using their power to do things that financial bidders would do, not things that strategic bidders would do. So they're doing it less often for operational changes. The fourth point of shareholder activism you see in 14A8, which you probably all know is precatory voting. What does that mean? It's not mandatory. It is advisory. It is permissive. But there's been a dramatic increase in the role of institutional investors using 14A8. So altogether, this is a noticeable change in the role of shareholders, and it's come about pretty much in the last decade or so. Second place where we've seen this change because of shareholder differences is in litigation. We see institutions becoming lead plaintiffs. As you probably know, the PSLRA of 1995 changed who would be a lead plaintiff determination in a securities fraud case under 10b-5, and instead of being first to file, it's now there's a presumption of the one with the greatest financial interest. That's likely to be the institution. We see institutions actually compared to, after 1995, the first 4 or 5 years, institutions were unwilling to play this role. Since 2000, they have been more willing to play this role, so we've gotten a substantial number of being lead plaintiffs. What is interesting, going back to my spectrum, the institutional investors, you don't see all of them doing it, you only see a small slice of them doing it. Who's doing it? Some public pension funds and some union funds are becoming lead plaintiffs, but no other institutions. Mutual funds aren't doing it, banks, insurance companies aren't doing it. It's a slice of that. Secondly, you see litigation via appraisal, that institutions are bringing litigation for appraisal. It used to be appraisal was only brought, I mean, we looked at a data set of cases in Delaware a few years ago, and appraisals were pro se cases. They were cases in which an individual would handwrite a complaint for appraisal. Now you're seeing sophisticated hedge funds because they can make money by litigating with appraisal. So these are areas in which greater shareholder power is visible. The third area is takeovers, because I think institutional shareholders have brought about a dramatic change in the state of play of takeover law. First, the classic Delaware structure. Classic means it goes back to 1985. The classic is three. I teach business. I teach law to business students, and you know, I dumb it, and I don't say that. Don't put that on there. Yeah, I simplify it. 3 rules. Rule number 1: trust directors. That's Delaware's rule number 1. You always start with that. I say, look, come to that point first. Trust directors. Delaware 141 says that much. Rule number 2: shareholders do only a few things. I tell the students that shareholders are like babies. They are simple creatures. Just like babies, they do 3 things. The three things for shareholders, different than the babies, are vote, sell, and sue. What's important is that it's not generic. They are not the plenary decision makers. They only are giving those three things to do. Third, we have a role for judges, and they are to principally police boards by fiduciary duty. Now, those fiduciary duties are owed to shareholders, but it's the court doing the enforcement as opposed to self-help. That's the Delaware structure. In such a system, when do you need defensive tactics? And the answer is not very often. You only need defensive tactics if you are not the decision maker, you the board. When are you not the decision maker? When the shareholders get those three things, and they're very limited. That's the only time you need defensive tactics. So what do? In the 80s, we settled upon an equilibrium. The board came up, Marty Lipton, that John's referred to a couple of times, very creative, came up with a poison pill. What does it do? It blocks the selling artery. Poison pills prevent shareholders from being able to sell. Therefore, the board gets to decide. The other thing you have to block voting. Actually, I was typing too late last night. I reversed my two verbs. Poison pills block selling, staggered boards block voting, and I apologize for confusing you that way. The point is, if you do the traditional equilibrium that existed for 20 years is that if you did those two things, poison pill and staggered boards, everything else was gravy. You could pretty much skip any other defensive tactic. And this was the norm for 20 years. And it made life simple for being a board defensive lawyer or for being a teacher, for that matter. This has changed in the last few years. Why? Because first off, the last instructional point is that each of these standard points had antidotes. The antidote to removing the poison pill and making selling effective was to redeem it. That meant the board had to act. To get the board to act, you had to replace the board. To replace the board, you had to do a proxy fight. It was costly and hard, but it was doable. But in the absence of that, the board had just say no, to use the Nancy Reagan term. So that was the antidote for poison pills. For staggered boards, you had to win an election, but you had to win two elections. You had to change the articles. The problem was that staggered boards are in the Articles of Incorporation, which if you've had corporations law, you know they can only be amended by the board and the shareholders, not by the shareholders alone. So it meant that in order to remove the staggered board, you had to replace the board in order to get them to propose the amendment to the articles. And to replace the board required winning at 2 consecutive annual meetings, which meant you had to put the money up and have to have staying power to do it twice, and that made it hard. But it could be done. But this equilibrium lasted from the late 80s, 1990, all the way through the last few years. The role of institutional shareholders in this changed. By the early 90s or so, institutional shareholders, mutual funds, and others were refusing to vote for a change in the articles if proposed by the board to insert staggered boards. So there really weren't any midstream staggered boards after that period. But you could get a staggered board in your IPO, and most everybody that did an IPO put a staggered board in there. Look at Google, look at everyone else. That equilibrium continued until the last 3 or 4 years, as Ed Rock noted in his commentary right before lunch. In the last 4 years, there has been this dramatic change in the reduction of staggered boards. All of a sudden, boards decided to give up their blocking power and let change occur. Why? Because there was a dramatic rise in 14A8 precatory motions to remove staggered boards, a dramatic rise in the vote received for those, but you got to add the third element. And the board, because up until 2004, even when a precatory vote got more than 50%, boards kind of drug their feet. They kind of ducked and weaved and they didn't do anything. And what's happened is that we've finally gotten a change that the board feels like they have to do something. Why? Because they'll get voted out the next meeting, or there is a credible threat of getting voted out, and that's because of institutional investors. So there's been this change, and so as Ed referred to in his last comment, it's now a minority of Fortune 500 companies. It's still going down. There's also a decrease in poison pills, but it's not as great not a great of an effect, because you can always put a poison pill back in one day. It can be done by board action at a special meeting, unless you have a bylaw provision that prevents it. Whereas to put a staggered board back in requires a vote of the board followed by a vote of the shareholders. And as I mentioned a moment ago, since for 20 years, institutional investors have refused to vote for that. So once you get rid of the staggered board in this world, it is gone. Poison pill could come back. What is interesting about how this has happened, and this is an illustration of a dramatic change brought about by institutional investors, it's been what I call a tag team. The public pension funds, CalPERS, NYSERS, tend to make the Wisconsin, Ohio have active shareholder. They make the proposal. In other words, the instigator of the governance change 14A8 tends to be a public pension fund. The mutual funds are willing to vote for it. Mutual funds are not willing to be an advocate, to be a proposer, but they're willing to vote for it. And the activist shareholders, the hedge funds, are the ones that kind of the fist in the velvet glove, that if the board doesn't respond, they are willing to take on a contest to remove the board. So what you have in this setting, unlike a lot of other settings, that you have this combination of public pension funds, mutual funds, and activist hedge funds taking on different roles that come together that have led to the removal of staggered boards. Now we haven't seen that in other settings, but we do see it in staggered boards, and so this is an example of how the role of public shareholders has left. And what does this tell us about whether shareholders are heroes or not? I think there's reason for skepticism. Shareholder activism, and this has been shown in several studies. Bill Bratton has a study that's shown this. Prof and my colleague Randall Thomas and Frank Portnoy have a study, and what they show is when shareholders get to be active and push for something, what do they push for? They push for changes that create cash, dividends, selling assets. This is what a financial bidder would do versus a strategic bidder I mentioned before. There is disagreeing data on whether shareholder activism improves operations. The Prof study says yes. The Klein-Zer study says no. There's some dispute about whether it does or not. I think in any event, this is a subordinate purpose of what we've seen for activism. What is interesting, a recent study that Lisa Fairfax is doing, looking at who is on partial slates, which is, again, something that's grown in the last few years. They tend to be financial types. In other words, who do you pick to be in your your partial slate? You pick someone that knows finance, not someone that knows operations or strategic. The last point is we had this flurry of activism for the last 3 or 4 or 5 years. It's gone. The 2008, 2007, when the spigot closed, before the meltdown occurred, that changed, and so we got to reset our learning. And so maybe this knowledge about activism doesn't carry forward, and so that will give us pause to be skeptical about what might happen. Second point, and the more thought point is, well, can we count upon shareholders to do the right thing? Are they the heroes in the topic that George has put for us? And I think it comes down to, can we expect shareholders to align with someone other than themselves, or are their interests aligned? Will they be aligned with employees and other stakeholders against management excess? And I think if you put it in historical context, I mean, the early part of the 20th century, I mean, we don't have the same history in this country as some other places of capital versus labor, but there is that strain of American history. Capital and labor being somewhat antagonistic. In contrast, in corporate governance, there's a long tradition, which means, at least since the New Deal, of seeing shareholders as the bulwark against managers. That they're the ones that will do the monitoring that keep managers in line. And so a lot of our thinking about corporate governance is we got to improve shareholder governance because that's the way we'll keep managers in line. And I think, as another one of Ed's comments before lunch suggested, there's reason to, the last year has made us rethink how that system works. Who are those guys? That was one of those. I don't know if you caught. Maybe I'm the only one that caught it. That was a title for one of the earlier slides. It's a quote from. Where's the quote from? Butch Cassidy and the Sundance Kid, sitting on top of the. Anyway, who are these activist shareholders? This, of course, is a picture of Carl Icahn, and where does he fit in? And to me, he's in the same genre as Lewis Wolfson from the 50s, taking Merritt Scott Chapman, and from Robert Young, the New York Central Railroad. And if you look at what's happened in the last year, what were shareholders' activism doing? The success I talked about in the earlier slides. They were pushing companies to take on more leverage. They were pushing companies to do things to take on more cash. And it's not just in the last 2 years. If you go back to this golden age of the 80s and Marty Lipton's earlier point, what is not remembered as much from that point is that the reason for the poison pill was a core distrust of selfish shareholders, that they were going to look out for themselves, that they were going to do what's happened in the last year. They were going to cause the corporation to take the money and run, to the detriment of employees, bondholders, those kind of folks. This is part of the fabric of Delaware corporate law. We have rule number 1: trust directors, because we're worried about, in part, shareholders being selfish. And we don't give unlike Eastbrook and Fischel and the market approach of the late 70s and early 80s, we don't let shareholders do everything because they will be selfish. At the same time, we don't trust directors either. We have a republic of shared power, shared controls. Boards need someone to monitor them, and the best monitor of boards is shareholders, but it's not unlimited monitoring. And that we have to have a theory of shareholder voting. Easterbrook and Fischel's was referred to this morning. They say that shareholders are residual owners, and therefore they're the ones best able to monitor directors. The recognition is that any contract, this is Easterbrook Fischel's a theory of gap filling. Any contract has gaps in it. Who fills the gaps? They say shareholders as residual owners have the right incentive to fill those gaps. They can delegate to directors, but ultimately it's residual owners. The problem is that leads to letting shareholders do anything, to take back the power anytime they want, and it ignores the Lipton learning that sometimes shareholders will be selfish. So I think you have to have an alternative theory. The alternative theory that's been common recently, Lucian Bebchuk and others say we don't have enough shareholder power. But that ends up not having much of a theory about shareholder voting. With a co-author, we have tried to develop an alternative theory for shareholder power, and our point recognizes that directors are the primary decision makers. Secondly, it recognizes someone has to monitor directors when they're conflicted. The shareholders are the best position to do that. But the third point is that shareholders have their own agency cost, and therefore it's important to not give shareholders unlimited power. So this is a separation of powers kind of argument. So what this cautions, I think, in terms of our shareholders, heroes or villains, is that you cannot make shareholders the plenary decision makers. That will not produce the best result. You need to have shareholders performing the monitoring role when they're best positioned to do that. But you have to keep it within the bounds of the three things that shareholders do. And that means that you ought to, there was another reference before lunch of shareholder voting being like voting in the old Soviet Union, as if that were, there's only one slate, you don't have a choice, and that must be a terrible thing. It turns out that this is not. It's a terrible thing if you think about voting as a democratic point of showing who owns who has the authority. That's not what voting works in a corporation. A corporation is different than voting in a political polity. In a corporation, we have markets. We have one share, one vote, but that's not one man, one vote. In one share, one vote. What if you want to change things? You can go out and buy the election. This is a kind of voting that Mitt Romney would love. If you care enough, this is a form of intensity voting. If you care enough about it, you go buy the shares. This is not anti-democratic or anti-American. It's not pro-old Soviet Union. It's how we govern a corporation with markets, with money. And so voting has a different role in corporations than in the democratic polity. And so we shouldn't be surprised if it works differently. And that should shape what we think the role of shareholder voting to be. And it ends up being not as important as we might think. And therefore, I end up concluding that this is not, we ought to let shareholder voting work in the space where it's best designed and not worry if it doesn't have a role outside that space. And that space is mostly to let shareholders vote when there's a change of control, to let them vote when there's a proposal for a merger, to let them vote when the directors are blocking a merger. But don't worry about making them vote or letting them vote to just fill out director slates. Don't worry about making policy. It's only when we want to throw the rascals out in a takeover contest that we really care about voting. So that's my pitch, and I'll leave it there.
All right, George, thank you so much for inviting me. It's a delight to be here, and I thank you, Bob, for leading off the session. I want to follow up with some of the things that you mentioned. My story is a much more narrow one. It's not so much about the corporate trends as a whole. It's a more specific look at one of the issues that Bob just raised, which is shareholder litigation. And I'll start by trying to answer the question that George has put to us, which is, again, institutional investors, are they the institutional shareholders, are they the villains or the heroes? In my story, they're more like the dogs that didn't bark. And the failure for them to bark in this particular story is going to lead some people to conclude that there was villainy afoot and others to say that nothing's going on. So let's start. We'll start with the point that Bob raised again, which is there's been a number of equilibria upset in recent years. And I think in my particular area of focus, which is mutual funds, that's particularly true. At the moment, we're seeing an incredible spike in litigation, all of which is coming to a fascinating head with the Supreme Court case in a few months. And it threatens to upset about 30 years of judicial precedent and about 40 years of legislation. So let's take a look. The case is called Jones versus Harris. Jones is Jones and two other people are plaintiffs. They're shareholders in a mutual fund that was run by Harris Associates, a Chicago investment advisory firm. This case made its way to the Seventh Circuit because it was based in Chicago. And at the Seventh Circuit, it ran into something that is guaranteed to immortalize it in casebooks from henceforth. Easterbrook and Posner. Easterbrook and Posner are like-minded fellow travelers. They've been espousing a very similar line about law and economics for a long time. But when they disagree, which is rarely, when they do, good things happen, at least for those of us who use casebooks to teach law students. Jordan versus Duff and Phelps is perhaps the most classic occasion on which they've disagreed, but I think this one may do one better, because in this case, not only do they disagree, but the Supreme Court thought that this disagreement was so noteworthy, they decided to take the case. All right. Well, what exactly is the case about? It's a good question. These days, when we think about what has gone wrong in the meltdown, it's difficult for a lot of lay people, I think a lot of law professors too, frankly, to figure out exactly where things have gone wrong. Not many of us know how to securitize assets. Not many of us know how to collateralize debt obligations. But if there is one thing we can all do pretty easily, it's read a 401k statement. And all of us know that our 401k statements in the last year or so have taken an enormous, enormous hit. What exactly has happened there? Well, obviously, a lot of the investments have gone down in value. What if you were to find out that in addition to the regular decline in the value of your 401k plan, the advisor to your plan had also been bilking you? My sense is that that would get your attention. That's the question that's at issue in this case. There are 90 million Americans who invest in mutual funds. That means that even though it's kind of an arcane topic, it probably affects us a lot more closely than tender offers do. I would say everyone in this room is probably a mutual fund shareholder. The number of us who have launched a proxy war, probably fewer than that. 12 trillion US dollars in savings in mutual funds, or rather more like 9.5 these days. We've lost about 2.5 trillion in the last 12 months. Okay. Executive compensation is probably the easiest, if not the most rational point of emphasis for a lot of people who look at the current financial situation and have a problem with it. Well, investment advisory fees in mutual funds are essentially the executive compensation. Investment advisors like Fidelity, for instance, provide their services to mutual funds and charge them for it. The mutual fund is nothing but a business corporation. It's an empty shell. It doesn't have its own employees. So essentially, the fees that a fund pays to its investment advisor are the executive compensation. And in this case, in this line of cases, in this explosion of litigation, the question is, are the fees that investment advisors are charging to their mutual funds, that is, all of us who buy the mutual funds, are they excessive? Well, that's a strange word to use. Excessive is a really weird word to use with people who study corporate law, because in a world in which markets determine the prices, words like excessive don't make much sense. It is either the price or it isn't the price, but a concept of excessive seems strange here. How can you insert that kind of language into this analysis? Well, the easy way to do it is through legislation. Most of the time, if you were to go and buy a car or any other sort of relatively unregulated product like that, if you ended up paying too much, if you ended up paying more at one place than you could have somewhere else, that isn't a cause of an action. You don't have legal standing there. You may have not done your homework. You may not have gotten the best price. But to say that the price you paid was excessive or legally actionable just doesn't make much sense. In the mutual fund context, that's not really true. Why? Because in 1970, on the 30-year anniversary of the two securities laws that govern mutual funds, the 40 Act, the Company Act, and the Investment Advisor Act, Congress revisited this area of law, which is really the forgotten securities regulations. The 33 and 34 Acts are the sexy ones up front at the beginning of the curriculum, and then lo and behold, every securities reg teacher runs out of time at the end of the semester, so we don't really talk about those other two acts. But they are quite important, and certainly with respect to mutual funds, they're sort of the be-all and the end-all. In 1970, Congress revisited them, revised the Investment Company Act, and one of the things it did is pursuant to a Senate report that said this industry is remarkably incestuous. That was their word. Because unlike most other industries, in this one, the investment advisor sets up the company that it wants, creates its own client, sets up a mutual fund, enters into the advisory contract with the mutual fund, sets the board of the mutual fund, all before outside investors join the company. We think, says the Senate report, that that's incestuous, and therefore, in order to protect against the inherent conflicts that occur in that situation, we're going to put in a new fiduciary duty. We're going to create it. This is, well, I don't think this is exactly what John Bogle has in mind with his federal fiduciary duty, but this is the federal fiduciary duty that governs investment advisors to mutual funds. Section 36B, an investment advisor shall be deemed to have a fiduciary duty with respect to the receipt of compensation for services. What does that mean? Well, it's tough to say. It probably means something with respect to these fees. People have been trying to figure out what this means ever since 1970. There have been lawsuits ever since that day in which shareholders in mutual funds have said, well, I think my fees are excessive, and I think the fact that the investment advisor is charging those fees seems to breach this fiduciary duty. It's got to relate to executive compensation. They're charging too much. Well, when this case reached the desk of Chief Judge Easterbrook last year, 2008, we had had about 30 years of litigation on this question. And all of those years, the cases had been determined by a Second Circuit precedent called Gardenberg, in which the Second Circuit had said, how do you figure out what's excessive? Well, let's look at a few factors. Let's see at how profitable the fund is to the advisor. Let's see whether there are economies of scale that they could be passed through. Let's compare what other mutual funds are charging for the similar kinds of investments. Let's look at those things. And the result has always been the same. Every case for 30 years. No violation of the fiduciary duty. These fees aren't excessive. When you look at those factors, those Gardenberg factors, they're not excessive. That's how it's been for 30 years, since 1982 to this case. When it reached the desk of Chief Judge Easterbrook, he said, yeah, you know, that's a standard in which plaintiffs never win, but I think it's a little lenient. I think it's a little lenient. I've got a better idea. I interpret fiduciary duty to mean something different than what these previous courts have said. There's no reason for us here, he said in his brief, in his opinion, to try and second guess things. We don't need to go in and try and figure out how profitable the fund is or whether other ones are. We have a perfectly good mechanism for that. It's called the free market. Right? If you open the pages of the Wall Street Journal, those pages are teeming, he says, with listings for over 8,000 mutual funds. That's exactly true. So if the fiduciary duty is cut back to something more minimal, like don't play tricks or don't pull the wool over your client's eyes, those are the phrases that Chief Judge Easterbrook used, then the rest of the pricing system works perfectly naturally. It's whatever the market bears. And this is a very competitive area, he says. And there's lots of funds and lots of advisors. So there's really no such thing as an excessive fee. And I can tell you, since I worked in this area in private practice for a number of years, that there was a loud hallooing and cheering that went up all across the nation's investment advisory offices upon seeing this case. Because they thought, well, it's true that under Gardenberg we've never lost a case in 30 years, but this one is even better. This one you don't even really have a prayer of bringing your case. One of my arguments to you today will be that this actually is probably one of the worst days in the history of the industry, not a day for celebration. Because ever since Easterbrook handed down that opinion, everything has been different. The equilibrium of 30 years is very much in the balance right now. Why? What's happening? Well, the first thing that's happening is the case also reached the desk of Judge Posner, Easterbrook's fellow traveler, Easterbrook's fellow judge, Easterbrook's fellow academic on the faculty of the University of Chicago Law School. Posner was not on the panel with Judge Easterbrook, but he is, of course, on the Seventh Circuit. And he voted to rehear this case en banc. There are 11 judges on the Seventh Circuit. One of the judges dramatically recused himself. The vote for rehearing en banc, which requires a majority, split 5-5, which means no rehearing en banc. But Posner still had a chance to dissent from the denial of rehearing en banc, and he did. And he did it in a way that I think is about as extreme as you can be within the polite confines of the Federal Reporter. He basically begged the Supreme Court to grant certiorari in this case. He said that the panel opinion's economic analysis is ripe for reevaluation. It is dramatically one-sided. And the plaintiffs understood what Judge Posner was saying, and they promptly filed a certiorari petition. And the Supreme Court, about 3 or 4 weeks ago, agreed, and they granted certiorari. So what exactly was Posner saying that so disagreed with his like-minded colleague? After all, both of these men, both of these scholars and judges have for the longest time agreed with a very, very rigorous interpretation. We've seen Easterbrook's name up on the screen 2 or 3 times already today. Both of them have agreed that the markets do work very well. But what I think is so fascinating about this case is that we are starting to see a dramatic schism, a dramatic rift, not just between Posner and Easterbrook, between many people who are classical law and economics thinkers who are being forced to reevaluate their views in light of what's happened over the last year. And that's not surprising. I think many of us are. But what's interesting about this case is the very different ways in which they're doing it. Easterbrook, at least in this opinion, has very much said, I'm holding firm. The market is fine. Of course, he had the ill fortune to hand his opinion down about 2 months before everything went to hell. And it might have made a difference if he had known what was coming. What does Posner say? How can it possibly be true that an industry like this isn't competitive? Isn't that what Posner is saying? It is what Posner is saying. What's his point of proof? Well, he says, take a look at the fees. If you look at the fees that institutional investors pay, and this is the not barking role that institutional investors play in this arena. If you look at what they pay for mutual fund advice, investment advice from these people, it's typically, on average, across the whole industry, about 20 to 30 basis points. That's what they'll pay. Retail investors pay about 50 to 60 basis points for the same funds. Same funds. And Posner says, how can you explain that difference? Doesn't that prove that the investment advisors, when dealing with a less sophisticated audience, is basically just jacking up the fees? Well, now, it's not exactly that simple. We need to explain this difference here. And the investment advisor industry will tell you it can be done. When you're dealing with retail customers, you have to provide a lot more services that cost a lot of money. You have to pay for websites, you have to pay for thousands of different statements, you have to have telephone operators standing by. It costs us more to service these kinds of clients, and that's why we charge them more. Well, that may or may not be true, but heretofore it hasn't been a required point for them to plead. They haven't had to prove it, and they've resisted proving it. And some people think they've resisted that because they can't. They can't justify the price differential. Well, we'll see. We'll see, because the Supreme Court's going to be asking them to soon. The Supreme Court has granted certiorari They'll be hearing the case in a few months. But a number of other cases have percolated up in the meantime. And a carbon copy case has just come down from the 8th Circuit a few days ago, last week, about 6 days ago. And the 8th Circuit looked at this case and said, on facts that were virtually identical to Jones versus Harris, and said, we agree with Posner. We agree with Posner. And that was the first federal opinion in 30 years that sided with plaintiffs in this area. And so you had a steady state of equilibrium of plaintiff defeats for 30 years. Easterbrook hands down his opinion, which is really dramatic and quite a departure from anything that's come before him. And since then, you've had Posner write his dissent, dramatically disagreeing with it, the Supreme Court granting certiorari in that case, and now the 8th Circuit agreeing with Posner. And one of the things that the 8th Circuit cited was, when we look for evidence that justifies this price differential between the institutional and retail rates, we can't really find it. But what we did find interesting was this email from one Ameriprise, that was the investment advisor in this case, to another saying, we may be asked about this differential and we should come up with an answer, whether or not it's convincing. They chose to quote that line in the opinion. Now, my suspicion is that with the help of a number of experts and a lot of data, the investment advisors probably do a fairly convincing job of making the case that these fees are justifiable, but we'll have to see. So what are the potential outcomes in the coming months? Well, obviously, there's the possibility of the plaintiffs winning this case. That would be really unprecedented. That would be just really quite astonishing. What would happen if the plaintiffs won this case? Well, arguably all that would happen is that you would send these cases back to the trial courts and say, in addition to all those other factors you have to demonstrate, you also now have to demonstrate why your prices are different for institutional retail. My sense is that investment advisors will probably do okay in the trial courts. They have for 30 years. They can hire a lot of experts. But they're going to have to choose whether to put more money into those litigations or to reduce the differential between their retail and institutional prices. I think it's going to be a hard job to raise the price on institutional investors, and that leaves the option of reducing the price for retail investors. So one way or the other, I think a plaintiff win here would clearly impose fairly dramatic downward pressure on the prices of mutual fund fees, which means that all of us would pay less, unless, of course, you hold shares in the investment advisors. What else could happen? Well, the defendants could win, obviously, and that would simply reestablish the equilibrium that we've had for so long of defendants winning these cases. I think that's a little bit unlikely, given the fact that they granted certiorari here, because the Gartenberg precedent is still in effect in most of the country, and it would seem an odd way to use one of your 80 cases a year simply to reinforce something that's already the law of most of the land. But it's possible, of course. And then the final outcome, and this is why I sort of suspect that one way or the other, Easterbrook's opinion is going to have been bad news for the investment advisor industry, is because it seems quite likely to me that in an environment in which so much of Congress's time in the coming year is going to be focused on hunting down new financial regulations to pass at the order of the President. President Obama mentioned that recently, that was a significant priority. I find it unlikely or difficult to believe that no member of Congress, when reading about this case on the front page of the New York Times in a few months before all our argument, will not find a reason to revisit this legislation, especially if the plaintiffs lose. If the plaintiffs lose this case, that will mean that notwithstanding the fact that Congress provided a right of action in 1970, no plaintiff has ever won a case in 30 years. If that's true, then surely some member of Congress might think courts don't seem to be deciding cases in the way that we wanted them to. My sense is that the odds are pretty good of that happening. But the reason why I think this case is such a good exemplar for us, especially those of us in the academic world, is because it's encapsulating a very fascinating time where Judge Posner seems to be revisiting a lot of his views about classical law and economics. He seems to be embracing, at least based on this dissent and the title of his new book, which is called The Failure of Capitalism, embracing a very different outlook on the world than the one that he's espoused for the last 30 years. He seems to be embracing, at the very least, a very much more behavioral mode of economic analysis, or potentially something even stronger than that. That's one thing that's going to be interesting to look for in this case. The second is this. The Supreme Court doesn't deal with executive compensation cases. Those cases go to the Delaware Supreme Court. This is a way in which an executive compensation issue may be presented to the Supreme Court. And it will be fascinating to see what the justices think of that, especially in this current zeitgeist. And the third thing that I think is going to be an interesting outcome from this case is courts, federal courts at the highest level, are going to be faced and confronted with a technical issue that isn't very fun to talk about, but is actually quite necessary in these cases, which is dealing with and deciding between dueling econometric analyses. You can be certain that both sides in this case will present experts who will say the market for mutual fund fees is competitive or is not competitive. And in order to prove that, you're going to have to run and demonstrate econometric analyses of the market. And the courts are going to have to look at those documents, which will be very difficult to read for anyone, and are going to have to choose which one they find more compelling. So those are three things that I think are going to be very fascinating about this case, which will, I think, to a large extent sum up a lot of what we've been seeing in the broader economic debate over the last year. Thanks.
Do a little switch over here. How do we do this? There we go. When Professor Dent invited me to speak, he said, "You're still a practitioner type, right?" Well, 107 days ago, I was. But I haven't been for 107 days. I'm a recovering corporate lawyer. For 27 and a half years, I practiced corporate law, primarily corporate governance and securities law. So I was sort of in the trenches for the last 27 and a half years about some of the topics we've been talking about. And one thing I want to make very clear, I'm not Marty Lipton. I am not Marty Lipton either in skill set, because he's brilliant, nor in attitude. So you may hear some things from me that Marty might not say. At the same time, I approach this as a lawyer who's advised boards and not CEOs. CEOs have never been my client. Boards have been my clients. Corporations have been my clients. I've either represented boards as a counsel to independent committees or as the people who have charge of management of the corporation which I'm representing. I have fired CEOs. I've hired CEOs. Represented the board in negotiations with CEOs. And that's something that's important to understand, because the viewpoint of a lawyer, who their client is very critical. Do we represent management? The answer is no. That's not our job. Some lawyers confuse that role. And the popular belief, I think, is that we all confuse that role. But I think most of us who go into a boardroom know who our client is. And it's not the chairman of the board, even if he is the CEO. It is the board as a group. And certainly that would be the attitude I think you would hear from most corporate governance lawyers who actually go into the boardroom. So I want to approach it from that point of view. The second point of view I want to approach it is as an Ohio corporate lawyer, which is very different from a Delaware corporate lawyer. Now, I bring to that not only 27 and a half years of practice, but I'm also the chairman of the Corporation Law Committee for the State Bar Association, and as such, I've been in charge of drafting the Ohio Corporate Code for the last few years. My term ends June 30th, and then it will be Bill Kelly down in Columbus. But for the last few years, I've been the one who's chaired the drafting of our statutes, and I've been involved in that process for at least the last 10 years. So I'm approaching it from the vantage point of an Ohio lawyer. Ohio corporate law is an interesting counterpoint to Delaware, which is what we've primarily been focused on today. We're a populous state. If you look at our Constitution, 1912 was an important time. That was an age of populism. Our Constitution was amended in those days. Our corporate law was created from that spirit. We actually believe in shareholder democracy. That's not what Wall Street will tell you, but that's the truth. The reason is you can look at our statute. You don't need board approval to go to for the shareholders to change the charter. The articles of incorporation in the state can be changed by the shareholders. Delaware, you need the board. We can eliminate classified boards by shareholder action. Doesn't take the board. We require shareholder approval of tender offers. That's a defensive mechanism, anti-takeover, but it means that shareholders get to vote on it. It can't be done on a Saturday night raid. It has to go to the shareholders. But more importantly, we're also a constituency state. We are one of the states, like Pennsylvania and others, in which by statute, the directors of the corporation may look to the interests of the community, the state, the economy, the customers, suppliers, employees, and other constituents of the corporation. And they can take them as co-equal with shareholders, not primacy of shareholders in this state. That leads to a very different model, perhaps, for corporate governance than the Delaware model. In Delaware, if shareholders are primary, then, of course, the boards must consider the shareholders first and foremost. In Ohio, they may consider the other constituencies, and that shows up in all sorts of areas, including our takeover laws. We come at it, and having testified in front of the legislature a few times, I can tell you that the people who are in charge of our law will tell you who the corporation exists for. It is not for the shareholders. The shareholders receive the benefit of the corporate law, which gives limited liability. There's a trade-off. The state of Ohio gets economic development, jobs. If you ask a legislature, which is more important, shareholder democracy or preservation of jobs, who votes, guys? It's not shareholders. So there is a contract between the state of Ohio, corporations, and the beneficiaries, the shareholders, that the shareholders get certain benefits, but they've given up certain things that in Delaware they may still have. We have anti-takeover statutes because of that. Okay, we lost a slide here. All right, one of the things that I bring to this is thinking about corporate governance as divided into two parts. One part is procedural. The other is substantive. Procedural is what's the structure, what's the system by which the corporation is governed? How is it done? Substantive is what happens, who runs the corporation, and what are the outcomes, what are the results. And this goes into some of the discussion that was talked about earlier. Procedure is something that corporate lawyers love. Why do we love it? Because we can handle it. We know how to draft guidelines and policies. We know how to deal with elections. We know how to put in place bylaws and in this state regulations. We know how to deal with that. We can set it all up. Boards like it because they can follow it all. And you know, this is something that has progressed a lot since I started practicing law. We always had agendas. We always had board resolutions. We always had reports. And now we have charters, much more formal outlines. We have corporate governance policies. We have all this stuff that came about because of Sarbanes-Oxley, the New York Stock Exchange, and NASDAQ rules, etc. We've made a lot of progress. We even have progress in how you elect directors, majority voting. I happen to be the person who testified before the legislature to say the shareholders of Ohio corporations need to have a way to throw the bums out. Okay? Shareholders didn't have that, at least in some lawyers' interpretation of our statute, which I disagreed with, but we clarified the law to allow majority voting. Well, majority voting to me is procedural. It's not substantive, because all you're doing is setting up the procedure by which you elect directors, not actually picking them. Here's the slide. Delaware, in contrast to Ohio, has no interest in its corporations other than the fees they pay. If you go into the Delaware legislature, what they care about is not jobs. There are very few jobs in Delaware that are created by corporations. The state collects a lot of money. I think it's double-digit percentage of their budget comes from the fees that are collected. So they have a very, very focused interest in corporations, which is collecting fees. New York lawyers, bankers, hedge funds, corporate raiders love Delaware. They're not at all upset to be in the Court of Chancery. They don't like takeover statutes. They don't like Pennsylvania. They don't like Ohio, etc. Okay, here's my slide on the dividing corporate governance into two parts. Okay. Shareholders love procedural corporate governance too. The reason why they like procedure is that it feels like that we meet the definition of corporate governance that's set forth in Monk's and Minnow's treatise on this subject. The definition is a structure that is intended to make sure that the right questions get asked and that checks and balances are in place to make sure that the answers reflect what's best for the creation of long-term sustainable value. And George, I'd like to point out, long-term sustainable value, not short-term. So if that's the definition of corporate governance, where did procedural corporate governance come from? Is it all driven by institutional shareholders? No. Good procedural corporate governance has come from many sources. There's lots of people who've been the fathers of what we have today. And we have to thank them all. They're all heroes to answer the question. Plaintiff lawyers have been heroes. That would shock some of my former partners. The Delaware courts have been heroes. Congress with SOX was a hero. The exchanges have been heroes. One of the biggest is the SEC's disclosure requirements. If you believe Louis Brandeis, that sunlight is the best of disinfectants and electric light the best policeman, disclosure compels good activity, good governance. Shine a light on it, people act better. Corporate counsel, even Marty Lipton, especially Marty Lipton in some areas, have pushed boards and have pushed managements to allow the board to work. I agree with the chart that was shown that shows the triangle. That when I started practice, it was much more heavily board linked with management. But I have seen in my years a very big swing to the more equilateral triangle. Boards aren't afraid of CEOs. You come in with bad results or too much greed, boards are quick to get rid of them, at least in my experience, or at least to take them to the woodshed and have a very serious talk. It is not a partnership between the board and the management team anymore. But directors have been a major force. One of the nice things about going into a boardroom is that you can almost always count on an activist director, not an activist shareholder, but a director who's awake, who's been reading the press, who's been reading materials, who's maybe been to a seminar that my friend and colleague Rich Kopis was teaching at, and has learned what a director's supposed to do. Ask questions, challenge, and has brought his own or her own ideas to the game. Where do I think we are in process? I think we're pretty good. I think we've made a lot of progress on process. I think there are still things to be improved. I think majority voting is not universally adopted yet. It probably should be. I think there are things on executive comp that need more focus. Compensation committees should never rely on management's compensation consultant. If compensation consultants are being paid by the corporation, there's an inherent conflict of interest, and I don't trust them. So that my view is, and recommendation to any board, is make sure you have your own. One that's willing to challenge the CEO's pay. Okay, I see little resistance in the boardrooms to the reforms that have happened over the last 5 to 10 years. I just haven't seen the pushback. As I think was said, staggered boards are being surrendered by boards, and annual elections are becoming a norm. I also don't see any cost at this point, major cost, from the reforms that have happened. Unlike SOX 404, which has put a huge burden on the financial side of the corporation and has cost millions of dollars per corporation for implementation. The reforms that came out of Sarbanes-Oxley on the governance side are relatively inexpensive. Most of the upfront cost is long gone. I'm sure that most of the work on corporate governance is now internalized to the law departments of the corporations rather than being sent outside. We still do some, but a lot of it's done on the inside. So it's good. But has this actually created a better decision-making environment? The reforms have actually been in place, many of them. And we've talked about it already. The meltdown of the past year, we had process. We probably had good boards. One of the examples I use is General Motors. I looked at the board of General Motors in 2002, the last board elected before SOX. 12 directors, 2 inside, the CEO and the president. Okay? 10 independent directors, that's a majority. It was a diverse board, had an African American, had a woman, Asian American, Spanish American, Hispanic American, a European, a Japanese. It had people who came from backgrounds of substance and knowledge about consumer products, which after all is what General Motors sells. So it was a consumer product. Manufacturers of consumer products. Someone from the finance side. Now, unfortunately, it was Stan O'Neill from Merrill Lynch, but yeah, at least in 2002, people thought he knew what he was doing. It was a quality board. They had one of the best corporate governance gurus as their board advisor from Weil Gotshal. Did they make good decisions? Well, a company that's about to go bankrupt is probably not in a good position to say they made great decisions. So do good procedures mean good decisions? And the converse, do bad procedures mean bad decisions? Remember the definition. A structure intended to make sure that the right questions get asked and that checks and balances are in place to make sure the answers reflect what is best for the creation of long-term sustainable value. I don't believe any system in the world can do that. I don't think any system can make sure the right questions are asked or that the right answers are given. Really smart people don't need such a system, or lucky people. And really dumb people can't ask the right questions or answer them no matter what the system. There's no checklist for this one. If we fixate too much on process, then we'll be like Abe Lincoln in 1862, who selected General McClellan to run the Army of the Potomac. He did a great job. He maintained beautiful discipline. He moved the Army to the York River Peninsula. Unfortunately, he couldn't whip Bobby Lee. Fortunately, Lincoln finally went to the drunkard and the madman. Okay? Would anyone elect Ulysses S. Grant or William Tecumseh Sherman to be a director of a corporation based on their history at the time that they were elevated to their high rank? For that matter, if you were choosing between Abraham Lincoln, a simple lawyer from Illinois, or a distinguished United States Senator, former high-ranking military officer, very educated man, and a major landowner in Mississippi, which would you have chosen? So, my point is, it's very hard to pick the right leaders. How can we ensure good judgment? Bob McNamara was a brilliant guy. Kennedy and Johnson were no slouches. Yet a few people in this room probably served in some pretty ugly places. Ehrlichman and Haldeman went to prison. Nixon didn't. Abu Ghraib happened. Abu Ghraib. And how do you really know what you've picked? Eisenhower said one of his worst judgments was selecting Earl Warren to be the Chief Justice. Now, I happen to think that Earl Warren was right. Some other professors may not, but, that's okay. What's the most important quality in a business leader? The willingness to take risks. How do you pick the guy who's going to lead you? The board is going to lead you. If you pick directors, they're willing to assess risks. That's what corporations are all about. Corporations, LLCs, etc., are all about allowing investors to deploy their capital take risks, but without personal liability. Sometimes you lose. And sometimes you lose because you didn't think. Sometimes it's because things are thrust upon you. Anyone who recognizes Nathan Bedford Forrest's Fustus with the Mostus probably went to Vanderbilt. Sometimes you do make judgments, mistakes. Eisenhower, one of the great generals of World War II, lost how many men at the Battle of the Bulge because he made a mistake? Grant lost thousands of men at Shiloh because he didn't entrench, and he lost thousands more at Cold Harbor because he made a stupid attack. People do make mistakes, and we can't penalize people for that. And the business judgment rule supports that. The Delaware business judgment rule, which is codified in Ohio, protects directors. The whole scheme is to allow directors to make mistakes. So who should pick the business leader? Well, George, would you please tell Interim Dean Rawson that I'm not suggesting the government? Okay, he would kill me. Management? No. Obvious conflicts. We should never let management choose. And I agree with that. The fact that it used to be that way, that was a bad thing. How it is today is much better. The existing board. Well, provided we've cleansed the existing board of being too close to management, they're in my mind the right people. Shareholders, I don't think, have enough information about the actual operating circumstances of the corporation. Only in egregious cases where the board is truly not being responsive to the operating conditions that the corporation is facing should shareholders take it upon themselves to throw out the existing director team. They can encourage the directors to make changes, absolutely. One of my problems with shareholders, I'm a securities professor. I used to be a securities lawyer. I have spent most of my life creating disclosure, writing proxy statements. Does anyone read them? Do you think investors really read them? I can tell you, I'm now a shareholder for the first time, and I've been voting my proxies, and I get a 100-page proxy statement, and I only read 3 or 4 pages. The ones on shareholder proposals, those actually interest me. I want to see what they're proposing. Because in terms of the board, I only read their bios. If they're on 5 boards, out. If they're on more than 3 boards, and they're not retired people, out. You know, if I don't like their bio, out. I voted no on more directors than I voted yes. Okay? But that's all I read. I don't read the comp section. God, I used to read those. I write those things. CD&A. Do I want risk metrics to be doing it? No, I don't, because there's no policeman. I don't know who risk metrics is. And I don't like the idea of voting the party line. I won't use, a special interest group's recommended list as a voter. I don't like institutions that do it, and yet I know many institutions that will follow the slate or the recommendations of risk metrics. And as a corporate lawyer, we used to go to great lengths to get risk metrics to recommend in favor of our executive comp proposals. We would go to great lengths to persuade them on takeover battles. I know their power. Stakeholders. Okay, I don't know how to give stakeholders a real voice in the election of directors, but I do like the fact that they have a voice in the boardroom. So, my own view, primary source of leader selection should remain in the existing board. Stakeholders should have meaningful protections from the tyranny of short-term investors, such as anti-takeover laws, such as constituency statutes. And shareholders should have an opportunity to show their disapproval of board leadership through majority voting requirements. And then they can throw the bums out. And I'm done.
Thank you. Before I take questions, I can't help one quick aside on David's presentation. James McPherson has a new book out on Lincoln as a war president. It talks about the process by which he took on one commanding general who didn't get the job done, fired him, took on another till he finally found the winning team, which was basically Grant, Sherman, and Sheridan. First of all Ohioans, number one. And number two, if you've never been to Sherman's home in Lebanon, do go. It's very interesting. His whole background, just his personal life and his story, as in a way, the creator of modern warfare is just remarkable. Yes, first question, and we have the microphone. Yeah, okay.
Okay. You're not giving the talk.
Thank you. Forgive my voice. I'm getting over a cold. Mr. Thompson, I have a two-part question for you. I'm sure you can answer it very briefly. What happened to the assets and clients of the two big banks that failed? And how do we get the major banks lending more money?
As to the assets and clients of the banks that failed, first off, trillions of dollars of assets disappeared, just don't exist anymore, and lots of customers are feeling it, including those in Ohio. It's worth trillions of dollars less than it was worth a year ago, and you can't spend it if you don't have it. The employees of those two firms have gone elsewhere. Many of them have taken their clients with them, but as was referred to before lunch, even the principals of those Bear Stearns and Lehman Brothers had billions of dollars of their own invested, which is not there anymore, and so there's been a real contraction of the amount of wealth connected with those two firms, even though the employees have gone elsewhere and the remaining investments of the clients have gone elsewhere. So I think we've seen this is why this is the worst financial situation since the Great Depression. As to how do you get the banks to lend more, I think it ends up being, it's not going to be corporate governance to institutional investors, it's going to be the government riding herd on that question for the short term, and I don't have an easy answer, but I don't think it's corporate governance.
I'm sorry, I neglected to ask Bob and William if they had any replies to anything that was said after them.
I'll give you a brief reply, perhaps on each one. On Professor Birdthistle's paper, which was very good. The question is, do we trust fiduciary duty or not as the vehicle versus some other vehicle for monitoring? And I just wrote a piece on Minor versus Salmon, which you might remember from law school, was the Cardozo opinion about punctilio, of an honor the most sensitive, which is our touchstone for fiduciary duty. And Cardozo believed in it. I mean, it was one of the greatest fun things I've done is write that article. He believed in self-abnegation, that you always put the other person first. And he carried it across the board. And so he believed in fiduciary duty. The other end, the book end of that, is the recent Delaware cases in which Delaware, because of the change in the Delaware statute and LLCs, Delaware now says you can waive fiduciary duty in LLCs in Delaware. And there have been a series of cases that let there be waiver of fiduciary duty. So what that says is we don't need it. And so the question is, okay, we have this space, fiduciary duty or not, where do mutual fund fees fit in? My sense is that in that Cardozo LLC waiver world, that markets do exist for mutual funds. There are 8,000 mutual funds. They charge different amounts of money. The money is disclosed. You can choose, and people do choose, and there are studies. One of the studies is mentioned in the brief that's in your materials, the study by Coates and the Dean of Columbia Business School. And so the question is, if markets, and certainly you were right to talk about the last year has been, makes all of us think about, well, markets haven't worked. We have to rethink lots of things. Even if we rethink markets, my guess is that the market for mutual funds remains an area in which we might well trust fees. So that's my comment about the first. On Professor Porter, new Professor Porter, 107-day-old Professor Porter, in terms of as a non-Ohioan, so I may be stoned before I get out of the room. I guess I was struck that, there's got to be a way to throw the rascals out in this majority vote. I don't think so. If you want to throw the rascals out, hostile takeovers is a much more effective way of throwing the rascals out. Majority vote is a pretty indirect way of throwing the rascals out. Now, it serves a purpose, but it's not a very efficient way. So I think as a non-Ohioan, Ohio does have. It's pretty protective.
And shareholders can approve hostile takeovers, and they do.
But it's still pretty protective compared to other states. And Delaware, Delaware folks will tell you there are a lot of jobs riding in Delaware, including the Delaware lawyers, and they care about how much money comes into their state. But there's a debate about that. So I think those are my two comments.
Sure, yes. As to Professor Porter's, I'll start with yours first. I'm not an Ohioan, and in fact, I'm barely an American. I just became a citizen a few months ago, and since I have a lot of research to do on my Civil War history to engage that question, but I will extend the conversation with Professor Thompson just one little bit, which is to say, it's true that the big problem with using fiduciary duty is, as another very famous jurist whose name escapes me now put it so well, deciding or concluding that someone or something is a fiduciary duty does not tell you the answer. It simply begins the question.
It's Frankfurter.
The range of fiduciary duties is enormous. Everything from, taking care of a minor child and raising that person to simply overlooking a lockbox. So that doesn't really tell you anything. I absolutely agree with that. And so one must look around to see what other sources of insight and wisdom there are. And the market is a great one. I think to complicate a little bit Professor Thompson's view and Professor Easterbrook's view of the mutual fund market, it's difficult to talk about a market that's so large as a market that works or doesn't work, because there are 8,000 funds, and the largest and most competitive of those funds are extraordinary. They charge rock-bottom prices and are very competitive. And the smallest and least traded ones are not that competitive. And so that may allow you to conclude good enough, but it does complicate the picture somewhat. And the Coates-Hubbard study is one academic study that supports the competitiveness of that industry. It is the only one that does. It is also the only one that is supported partly by the ICI. All other academic studies conclude that there are troubles in that area. So it's a complicated picture. It doesn't do away with the question of whether or not the courts are the right place to go to figure out the answer. That's why I think the Supreme Court's decision is going to be so interesting, because they're going to have to do something, and they may not be very well equipped to do it.
Another quick digression on Bob's comment about Meinhardt. Why did Cardozo insist on a punctilio of an honor the most sensitive? He came from a venerable Sephardic Jewish family, but his father, who was a member of the Tammany gang, had disgraced the family and was convicted of ballot box stuffing, and this really humiliated Cardozo, so he was very sensitive about matters of honor throughout his life. Next question. Yes, sir.
Yes, when I first began practicing, shareholder derivative suits were the primary mechanism by means of which the director's fiduciary duty to the shareholders were enforced. And of course, in the 80s, clever lawyers came up with the so-called independent committee, and the shareholder derivative suits faded away. We have a sort of half-baked replacement in the class actions. My question is, do you think it's time to bring back the shareholder derivative suits as part of corporate governance?
You are right that there's been a dramatic decline in derivative suits. We did a study that showed that of Delaware litigation, only 15% of all litigation is derivative suits, and that's a dramatic decline. Even though all the case books remain full of derivative suits, they don't matter much anymore. Is it because of independent committees? Probably. Although there's a new study out by Professor Myers at Brooklyn that says that derivative suits, the independent committees do not dismiss suits 100% of the time, the way that 20 years ago we thought was the case. But remember, the crucial thing about derivative suits, Sarbanes-Oxley has brought about a requirement that boards be majority independent, and with the independent committees requirement, they're mostly independent, and so it really comes down and goes back to one of John's points first thing this morning is, can we trust directors or not, and can we trust independent directors or not, and derivative suits remain a fail-safe device for the courts to review conflict of interest in what may be structural bias. So I'm comfortable with derivative suits remaining as a check, but I think the growth in independent directors has decreased the space for derivative suits compared to 50 years ago or 30 years ago.
Yeah, I'd agree, except that in Ohio it's even more so because the statutory standard for damages is so tough. It takes away the incentive for plaintiffs' lawyers to bring a case when they have to meet the higher standard of proof and the higher standard of culpability. I mean, if you have to be grossly reckless or intentional, it's a bit harder to prove, and when you have to have clear and convincing evidence, which is, I believe, the statutory standard, that's more than the Delaware court would have looked for.
But, my mailbox still fills up with solicitations from plaintiffs' firms seeking my proxy and sue Citigroup or whomever.
Is that for security? Is that for fiduciary, or is that for security suits?
Securities, yeah.
Different.
Yes,
Different cause of action.
all of the plaintiffs' work, the same law firms tend to do both types of work, and they found that securities fraud class actions are a much more lucrative way than state derivative suits, partly because of the demand requirement in state derivative suits. But the net result is that a lot of corporate governance is getting brought up and resolved in federal court in class actions, and then there's been a real shift of even discussing state law governance issues within the framework of a federal securities fraud class action.
Can I, George?
Yeah, okay, I think we have time for one last question.
I'm just wondering, you guys, I think the shareholder activism, I think the movement in corporate governance based on, that is provoking shareholder activism, or it's based on shareholder activism, at its root, I still think it comes from some populist belief that it has to be better governance if shareholders are more active, and it's like it's the level of analysis or sophistication in that assumption is based on basically a middle school civics understanding of democracy. It has to be better, and I am not. So first of all, I think it's disquieting. I'm not sure that increased shareholder activism is necessarily good, and I'm not sure that this populist movement that it's based on is going to lead to either better governance and certainly better results. And I just wonder where you guys would see that.
I think it could be populist, but to me it's also Ronald Reagan's famous quote that at the debate says, "I own the microphone. I mean, it's my microphone. I want to talk." Ownership is what I think is based on. I think that's oversold, because I think shareholders, as I said in my remarks, shareholders have a role to monitor boards, but it can easily be exceeded. And I think, going back to something David said, I think there is a connection between corporate governance and public policy governance, in that we believe in checks and balances. And so it's not that shareholders are populists or shareholders are owners, it's that shareholders are part of a check and balance, and you've got to understand the system. Now, that's complexity, but I think that's what best describes the corporate governance system that works in America.
Right. Ed Rock had to leave, but he and I were talking earlier about something that he's examining, which is of interest to me because having represented many dual-class corporations or time-phased voting systems, one of the fundamental questions that would probably separate me from George is I do think about something about long-term investors having more clout in the discussion than someone who just arrived, and that may be, hey, I don't know, I think you need to be here a few years before you get to vote in our presidential election, so I can carry it over into the corporate world. But I'm very happy with companies that have a time-phased voting requirement that gives more clout to people who've been there a little bit longer, because while they may well change the direction of the company, they may agree to sell the company, they better meet the long-term sustainability concepts of corporate governance, and they certainly better meet the policy reasons why the state of Ohio wants them to be incorporated in the first place and give them limited liability. It's a longer-term view. So I guess my biggest problem has always been with the Johnny-come-lately investor or speculator, whatever, depending how you want to view them, who comes in for the quick buck. Because to me, that's not giving enough credence to the long-term value of the corporation to the community as opposed to particular market at the time.
I agree with Professor Thompson. As an outsider, if you look in at America, I think you would be convinced right away from the level of popular rhetoric that America is a direct democracy. It isn't. It isn't. It is a Republican form of democracy. Right. And that's just not, American Idol teaches us that we just need to text in our view, and that will be the truth. That is also why I fear direct democracy, and why I have become a citizen of the Republican form.
Did you hear her saying?
Well, we really are out of time. I disagree with David, and that's it. I won't say anything more about it than I've said it before, but I won't go on any further. Again, I think this has been a great panel, and thank you all for coming, and I hope you've appreciated the symposium and enjoyed it as much as I have. So thank you.